Now I am coming with one more part of our constitution. Today I am going to start the procedure for amendment. This is chapter 10. The nature of the amending process envisaged by the makers of our constitution can be best explained by referring to the observation of Pandit Nehru, quoted under reconciliation of a written constitution with parliamentary sovereignty, NT, that the constitution should not be so rigid that it cannot be adapted to the changing needs of national development and strength. There was also a political significance in adopting a facile procedure for amendment, namely that any popular demand for changing the political system should be capable of realization if it assumed a considerable volume. In the words of Dr. Ambedkar explaining the proposals for amendment introduced by him in the Constituent Assembly, those who are dissatisfied with the Constitution have only to obtain in two-thirds majority, and if they cannot obtain even a two-thirds majority in the parliament elected an adult franchise in their favor, their dissatisfaction with the constitution cannot be deemed to be shared by the general public. Elements of flexibility were therefore imported into a federal constitution which is inherently rigid in its nature. According to the traditional theory of federalism, either the process of amendment of constitution is entrusted to a body other than the ordinary legislature, or a special procedure is prescribed for such amendment in order to ensure that the federal compact may not be disturbed at the will of one of the parties of the federation, viz. the federal legislature. But as has been explained at the outset, the framers of our constitution were also inspired by the need for the sovereignty of parliament elected by universal suffrage to enable it to achieve a dynamic national progress. They therefore prescribed an easier mode for changing those provisions of the constitution which did not primarily affect the federal system. This was done in two ways: by providing that the alteration of certain provisions of the constitution were not to be deemed to be amendment of the constitution. The result is that such provisions can be altered by the union parliament in the ordinary process of legislation, that is by a simple majority. Other provisions of constitution can be changed only by the process of amendment which is prescribed in Article 368, but a differentiation has been again made in the procedure for amendment according to the nature of the provisions sought to be amended. While in all cases of amendments of the constitution a bill has to be passed by the union parliament by a special majority, in the case of certain provisions which affect the federal structure a further step is required, viz. a ratification by the legislature of at least half of the states before the bill is presented to the president for his assent, Article 368. But even in these later groups of cases, the law which eventually affects the amendment is a law made by parliament, which is the ordinary legislative organ of the union. There is thus no separate constituent body provided by our constitution for amending process. The procedure for amendment is: an amendment of the constitution may be initiated only by the introduction of a bill for the purpose in either house of parliament, and when the bill is passed in each house by a majority that is more than 50% of the total membership of that house, and by a majority of not less than two-thirds of the members of that house present and voting, it shall be presented to the president for his assent, and upon such assent being given to the bill, the constitution shall stand amended in accordance with the terms of the bill. If however such amendment seeks to make any change in the following provisions, namely the manner of election of the president, Article 54 and 55 extend the executive power of the union and the state, Article 73, 162, the Supreme Court and the High Courts, Article 241, Chapter 4 of Part 5, Chapter 5 of Part 6, Distribution of Legislative Power between the Union and the State, Chapter 1 of Part 11, any of the list in the 7th Schedule, Representation of the States in Parliament, Article 80 to 81, 4th Schedule, Provisions of Article 368 itself. The amendment shall also require to be ratified by the legislatures of not less than one half of the states by resolution to the effect passed by those legislature before the bill making provision for such amendment is presented to the President for assent. Article 368(2). This is all about today's part of Constitution.